All right, everybody, welcome to the Creative Finance Collective. Just bringing on a couple folks. We have joining us here Sean St. Clair and Alan Seschker. Alan, can you hear us okay?
Yep, I got you.
Hey, thanks for joining us. I know you got just a little bit of time.
You bet. You
Um,
bet.
for those that are just joining us, this is the Creative Finance Collective. So, what is the Creative Finance Collective? That is an opportunity for lawyers like the three of us to get together and talk about creative finance, what we're seeing in the creative finance space. And it is an opportunity for us to discuss what we're seeing in different jurisdictions. It's also an opportunity for us to engage with you, the listener, and answer any questions that you might have. Now, right now, we have a variety of different lawyers that come on to the collective to talk about creative finance. But right now, we're represented by the state of Arizona and Texas. Alan's from Texas. Sean and I are from Arizona. So we may not be in your state if you're listening. We may not be able to answer all your questions. This is obviously not legal advice, but we can do our best to direct you and try to give you an idea about where you need what you need to be thinking about with regard to creative finance type questions. The rules that we play by here is we'll stay on as long, well, as any of us can, but at a minimum, we'll be here until there are no questions. And if there are no questions, then we'll move on with our evening as we'll let you do the same. So we'll wait a few minutes as we wait for people to join, and and then we'll go from there. Let's see. Sean, I wanted to ask you a question while we wait to see if we get any comments. Alan, for those if you didn't watch, was on our podcast earlier today. We were talking about uh, the top 5 things to add to your contract to improve it in creative financing. And one of the things that I thought is worth bringing up that we really didn't, I don't think, talk about too much on the podcast earlier was mistakes that you've run into where folks haven't got the purchase price right or haven't planned for a static or had made it a static purchase price. Is that something you're still seeing or dealing with? I know it's still something that you've wanted to have built into the contract.
Yeah, that's always the hard part is figuring out what's static and what is to be adjusted. And so if your contract doesn't have the right, language, then you get to closing, and if the numbers don't add up, something has to be adjusted. And if you can't get both sides to agree, sometimes it can be, detrimental to the buyer. The most common example is, you put a purchase price down based upon what you think to be the payoff amounts of the loans, and unbeknownst to you as the buyer, the seller has paid down more of that principal than you thought. And then you get the payoff, and you're like, oh, there's 10,000 less principal than I thought. Well, if the purchase price is a static purchase price, you either have to make up that $10,000 difference with additional seller financing or with additional cash at close of escrow, versus having a provision in the purchase contract that says, in the event that the loan balance comes in lower than the amount listed here, the purchase price will be reduced, to reflect that change in the principal balance. I mean, is that
Alan,
how you kind of set it up, Alan?
Yeah, I do what's called a math word problem. I say the purchase price is the assumption of the outstanding principal balance of the existing mortgage at time of closing, plus X dollars to seller if they're getting an exact amount, $3,000, what have you. But
Right.
but we have one right now where buyer and seller are arguing back and forth because of that exact issue. They put a static price in there. Closing took longer than they wanted it to, so now there's additional dollars owed, and they're fighting over who owes it. So it's very common.
Right. Yep, it's very common.
so we have a question, and Alan, you're the rap king kind of thing, so we'll let you maybe tackle this first. But the question is, when doing a rap, how is the second loan recorded?
You think they're talking about the second loan that we're drafting up?
It doesn't specify, but I think that's what it's.
Presumably.
Yeah.
So, well, let's do it both ways. If we're dealing with just one lien, then we're drafting up our loan documents, our wrap documents, and that gets recorded and just takes a second lien position. A lot of times we're dealing with multiple liens, especially home assistance, home buyer program, or HUD lien, or what have you, and those all get wrapped into the exact same second lien document. But then every once in a while, there's what I call gap funding, or closing cost funding. And so a private lender is coming in and providing that lien. Just recently, we decided we're going to start recording that private lien before the wrap lien, and that way it gives that private lender additional protection. I hadn't thought about that, but I don't know if y'all know Nick Legamaro. He brought that to the table for us.
So interesting. So what language have you added to your purchase contract or other documents so that the seller knows that, hey, look, I'm going to be now behind some other lender as well, which if I'm the seller, knowing what I know, I'm not liking that very much, because if I foreclose, then now I have added debt to my property than what my original deal was with the investor, right?
Yeah, we've only done them with that Nick fella, and he takes care of all the negotiating, gets everything worked up. It goes into special provisions. So I haven't had to advise on that. If I was advising the seller, you're absolutely correct. I'm saying no way. You're not selling the property. You're not giving that private lender superior lien position. But Nick negotiates that and gets them to agree.
But on the flip side, I mean, if that private lender's stepping in and stroking you at, let's say the private lender's coming in and buying out the equity in the property, and stroking you, the seller, a check for 50 grand or 100 grand because that's what your equity is, then I could see the argument, well, no, they should be ahead of you because you're getting their money as part of the purchase.
Yeah.
So
yeah, if it's equity now, a lot of times it's reinstatement and closing dollars, so no net improvement to the seller. So I can see it causing problems. And it's never going to occur on the consumer wrap transactions, the retail wraps.
Yeah.
If you're just now joining us, this is the Creative Finance Collective. What is the Creative Finance Collective? It's an opportunity for lawyers in the creative finance space to get together and talk about what they're seeing in that space. But we're here to answer questions from you, the audience, about creative finance. So the rules of the game for the collective are we'll take questions throughout the hour or until we stop getting them. So this is a great opportunity for you to bring to the table any questions that you have to address issues or concerns that you've run into when dealing with creative finance. Also, there is a barcode at the top of the page. It'll take you to the NREM podcast, which hosts the collective. And that can be found on Facebook, YouTube, and X. That link takes you directly to the main page, which is the YouTube page. We have another question. Is it possible to buy a house in a day? And I'll just jump in there, and I think that's possible. That could be done. It might not be a good transaction. It's risky, but you might buy it subject to a lot of things potentially. Yeah, maybe buying a house in one day is the ultimate creative finance transaction, the ultimate subto transaction. You're buying it subject to everything. What do you guys think? Can you buy a house in a day?
I cheat with this answer. We have closed in less than 24 hours. However, it was a contract after the transaction failed, so we already had that title search completed and wrapped everything up for the second contract. So, and I agree 100% with you. It's dirty, it's messy. You're leaving yourself wide open for mistakes and problems.
Yeah, like Andy said, I mean, you could do it. I mean, all it takes to technically buy a house is a warranty deed, right? I mean, you don't even need to go through escrow. I give you X, you give me warranty deed, I record, and we're done. That could all be done in a day. The problem is, like Andy said, like you don't know what you're really acquiring, and what's out there. To me, title even aside, it really depends on where the property is, right? So if the property's in an HOA, no, you're not closing in a day because you got to get the HOA disclosures. I mean, that's required by law, at least here in Arizona. And they're not going to give them to you in a day. They're going to take their time, as much time as they're allowed under statute. It's those types of things that make it difficult when you have to rely upon third parties giving you documents and information.
Yeah. We got another question. What is the process of extending a balloon payment for a subto transaction? So I think this assumes there's a balloon payment on one of the notes or the note. What would you say that process is, other than negotiating an extension of the balloon payment with the lender? I mean, what else can you even do?
I mean, I don't think that's going to occur.
Yeah, I mean, and why wouldn't that occur, right? Because a typical creative finance transaction, we're almost always talking about a residential, right? And we're talking about investors going after like a 30-year fixed, amortized over 30 years. Maybe this could happen in a commercial deal, but in a residential deal, it doesn't seem like it's very likely. But beyond all that, I mean, to get that balloon payment extended, that would be something you would literally have to go to the lender and negotiate that, right? Am I seeing this wrong?
No, you got it. And I think if it was a private lender or hard money lender, and they're not going to call that thing due, you can do that. And we actually have one right now, IRA lender. It was conveyed subto to someone, and they're negotiating an extension. But you're not going to do it with Wells Fargo or Mr. Cooper.
Right.
Yeah. All right, we have another question. This is a good one, I think, Alan. We just kind of talked about this earlier today. If I'm just starting in real estate, should I use an LLC with trust or just start with an LLC?
I like just the LLC. What we're seeing is folks using a trust with the LLC as a beneficiary to try to create anonymity and things like that. But I think it gets pretty convoluted when you start doing all that. We see these people setting up these, $7,000, $8,000, $9,000 cost for the parent entity in Wisconsin, and then sub entities over in Nevada, and it's just too much. Get yourself an LLC and go, is my opinion.
Well, I'm going to come at this from a little bit different angle, because I'm with you, Alan, as far as the land trust and the anonymity and stuff. But I'm going to come at this a different angle, which is your succession planning techniques or your estate planning techniques, right? So, if you just go out and form an LLC and you name yourself as the, primary member of the LLC, and you're, rendered incapacitated or, deceased, all of a sudden now there is no, process to install somebody in short order who can continue to manage that real estate empire if you've built it. And so I personally think that, not so much from a fancy asset protection or, anonymity perspective, I think that, everybody who's working on building a company and building a business should have succession in place, and that includes for them personally as well. Have a trust on top of there, so that if something happens to you, immediately a successor trustee can step in and start managing your affairs, and you don't have to wait for the probate process. You don't have to go through that process. It gives you the ability to just make sure that everything's in order and there's a succession, and that can even have provisions to protect your kids, and you give instructions to your successor trustee like, hey, this is a good cash flowing asset. Do not sell this while my kids are still minors. Let them make the decision when they become 18, and you just manage it, and then they can decide, what they want to do with the asset. I think all of that needs to be dealt with, and from the beginning, because it's harder to kind of unwind it if you put a bunch of stuff in place and then it's like, okay, now we got to restructure so that, that estate plan or that trust, family trust is kind of at the top of that list.
Now, do you do any trust work?
We do. Yeah, I do estate planning work as part of my practice, along with LLC formations.
If you're getting what I call a real trust in place, estate planning trust, is there do you do that lump sum cost, or what's the cost to enter that?
So for us, a married couple, it's $4,000, but that's your entire estate plan.
Okay. That's not too cost prohibitive.
No, it's not too cost prohibitive. And, and then I have clients and savvy clients who do interesting things because, for lending purposes, if the wife owns a greater percentage of the overall assets, the wife can go and get a loan in her name, and then the husband can get a loan in his name, but they want it all estate plan. So you can do, kind of unique things with like having one trust for the spouse and another trust for the spouse that all flows up into the family trust, so that you can then restructure or amend your LLCs to put greater percentages into one spouse versus another for lending purposes, if that makes sense. So that can get kind of fancy. That's not anonymity. That's not asset protection. That's more of, planning for, financing and stuff like that.
All right, folks, if you're just now joining us, this is the Creative Finance Collective, and we're taking questions about creative financing or real estate throughout the hour, and we'll take them until we stop getting them. And we have another question. If I cancel during the inspection period and the seller says they want to keep the earnest money because they could have accepted a different offer, would they keep the earnest money?
You're talking about this today.
Yep. So no, they can't rightfully keep it. In Texas, they can lock it down by having both parties make a claim to that earnest money, and then title office is going to be locked down. Today, we did talk about some language that we can insert in there that would allow a title office to look at it and see, all right, termination during option period, I'm releasing this back over to the buyer, and the seller wouldn't have a claim against the title office. But it could be locked down.
Yeah, it's kind of the same here in Arizona. If a seller comes out of the woodwork, has a good faith basis to hold up the release, but a good faith basis is not, I could have gone and marketed it during the inspection period. No, the whole purpose of the inspection period is that the buyer has the opportunity to inspect and do due diligence and decide if they want to move forward with the transaction. And we also talked about this to answer this question even, so to avoid maybe a seller ever coming out of the woodwork and doing something like that and objecting on that basis, you can put into your purchase contract that the earnest money actually isn't delivered until the inspection period is done.
I like that.
And that would avoid that,
I like that.
That's interesting. Hey, Alan, I'm curious to see what you had, well, both of you, since we're really coming into the end of the first month of 2024, kind of a temperature check. We've had mortgage rates kind of come off their highs that they were in last quarter or maybe the third quarter of last year when they really hit their peak. They've come off. I don't know whether that's had any appreciable impact in the housing market. I'm curious, since you close a lot of creative finance, subto transactions, did you seen any change coming into the beginning of the year? Is it still as hot and heavy as it ever was?
It's still fast. We're actually seeing now a lot more of the consumer wraps. So I was just on the phone with someone. They had a $1.6 million house. It wasn't moving very quickly. They then switched over to maybe renting it. Their agent brought the idea of mortgage wraps to them, and they said, okay, yeah, let's try it. They immediately got a buyer. And so we're closing that mortgage wrap consumer transaction. So, I mean, I would have to look at January numbers. January was down a little bit from December, but that's because everyone wanted to finish up in December.
Right.
You need to ask me that question end of February, and I
Okay.
can give you more.
Temperature, or probably even a better temperature check would be like if give it a full quarter, see what that looks like. It seems like it's been still remained hot. Just curious to see as the interest rates, or at least if they have recently dropped, whether that's I haven't. It hasn't seemed like it's spurred aggressive conventional selling growth, but I'm not as tapped into that. I don't know. Sean, have you seen any slowdown in any of that?
No, I don't think it's yet spurred buyers to jump out there. I think buyers right now are still kind of waiting in the wings to see what interest rates, do. And even now, the inventory is low, but your buyer pool is a little low right now. So my understanding is, at least what I've read, things aren't moving particularly fast, but in any event, yeah. So I don't know. It's not too bad.
Yeah. All right. Hey, Alan, I know you got to get going here, don't you?
I do. Got early dinner with family.
All right. Well, thank you. Thank you for being with us. I'm always happy to have you on, and we'll see you next time.
Okay. I'm looking in advance at one of the questions. Con of real estate agent is you can't go around a real estate agent to talk with the seller directly. So I'll leave you with that.
Oh.
Okay. Awesome.
All right, guys. We'll see y'all.
All right. We'll talk to you
All
later.
right. Thanks, Alan.
No, bye.
Bye.
If you're just now joining the show, this is the Creative Finance Collective. And as you just watched, the Creative Finance Collective is designed for lawyers for an hour to come on and off as they have time and can be a part of it. And there's times where we have 5, 6 people, and sometimes where we have just Sean and I. So Alan had to go. So Sean and I'll continue taking your questions. We're here to discuss creative finance and answer questions. So if you have them, we're going to answer questions until we stop getting them. And what Alan was referring to as he left is we had a question. What would you guys say are some pros and cons of being a real estate agent?
So I think the best thing to answer that question would be and I don't know when we shot it, but it's on our in-rim page, our YouTube page, the QR code's up there. Look for our episode with Templeton Walker, who is an investor and real estate agent here. And he basically lays out how he uses his real estate license to basically offer kind of full service options and to work with other agents, to work with sellers and buyers, as well as, how he integrates that with his investment work. And then as far as cons, I mean, obviously you're subject to additional and higher regulation and ethics and things like that, which you should be ethical anyway. You should be complying with those regulations anyway. You shouldn't be doing anything bad. But, so I'm not sure there are cons, but there are additional disclosures you have to make if you're entering into a transaction, even on your own accord when you have a real estate license. So I don't know, definitely watch that episode with Templeton Walker. And I think, you'll see kind of how he uses that real estate license with his investment work.
Yeah. I think he's found it to be, when you look at these folks that are kind of dual, both investors and real estate agents, where they kind of wear both that hats, they're able to use that pretty effectively. But that would be a good episode. Another question: should we always have a balloon extension in our contract?
I mean, to each their own. So if you're taking a property subject to and there's no additional seller financing and you're purchase contract and your performance note all state that the maturity date mirrors the existing loans or loan, then, obviously that's a moot issue. But, if you're doing seller financing and you want to negotiate with the seller that, hey, look, let's have a 5-year, or if the seller's pushing for a 5-year balloon, say, yeah, I can do a 5-year balloon, but under certain circumstances, I can extend it. You figure out what those circumstances are. Sometimes it's an additional principal payment. Sometimes it's, a additional, extension fee that you have to pay to the seller. And then other times it could be based upon the market and the ability to, do a disposition of the property. There's a number of factors you can use for that extension, but nevertheless, yeah, it doesn't hurt to negotiate it, but I'm not going to say, always is the rule. I think it's just a negotiated term that you're going to want to figure out if it's appropriate for that transaction and that seller.
So we have another question. What would you guys say is the most competitive side of real estate?
I don't know if I could really answer that.
Yeah, I think that's hard for us on the legal side of things to answer that. I know, regardless of your real estate strategy, so your, how you like to invest, I'd say one of the ones that's pretty darn competitive is just making contact either with agents or distressed sellers.
Right.
Competing with the other investors to get that ear.
Yeah.
Or what would, Brett Daniels say, tell your story, have the opportunity to tell the story and do that. That's probably where there's a lot of competition, but yeah, which one's more competitive? Not really sure. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour on all things creative finance related. We also have a barcode up at the top of the screen that goes to the NREM podcast page on YouTube. If you're not there already, that's just the best place to follow us for this kind of content. Every week we do the Creative Finance Collective, which has lawyers in the space of creative finance to answer questions that you guys might have. And we take questions until we stop getting them. Well, we wait for potentially any other questions. Well, we did have another question. It wasn't really related to creative finance, but for property, does water take away acreage on your property? I think the best way I would look at that is, I don't know of any reason that it doesn't. It certainly takes away usable acreage if you want to build. If you've got floodplains or existing water, you're not going to be able to build. So it takes away maybe usable acreage. But I don't have any knowledge or reason to believe that because water's on your property, that it, for purposes of the legal description, changes the amount of acreage on your property. I don't suspect you've seen anything different, Sean.
No. And while I'm now licensed in Arizona, it's recently or Wisconsin, excuse me. It's recently licensed, and in Arizona, we don't have tons of lakes, especially in, Maricopa, where people own property on lakes and stuff like that. So, and rivers, so that's more of a rule type question that unfortunately I don't know much of the answer to.
Yeah, at best we get the floodplain type issues,
Right.
where theoretically they've decided not theoretically, they know water flows in a particular area, so they treat it as a floodplain. And that is for sure going to limit your usable square footage or usable acreage, what they'll allow or permit to build or whatever else. But I don't think that changes the amount of your actual acreage that you're purchasing for purposes of a legal description. In any event. Well, guys, we're slow on questions at this point. Maybe we've answered them all. We'll give it a couple more minutes to see if we've got any other questions. Any new things you've seen in the creative finance space lately? Mistakes that are being made out there?
No, I mean, I'll expand a little bit on my legal update from this morning, which is the importance of having that, assignment language in your documents. I had a recent transaction that it looks like we're going to be able to close on under a contract for deed or agreement for sale, where the investor purchaser wanted to sell to an investor buyer. So they were going to do some weird thing and try to unwind the whole thing and get a warranty deed from the seller, but the seller wouldn't cooperate. And so then they were like, well, how do we, go about this? And so I took a look at the agreement for sale, and lo and behold, it was somehow a local title company got a hold of my agreement for sale form and started using it.
A title company did?
Yeah, some title company got a hold of my agreement for sale form and somehow got it, and they, started using it, and so they sent it over to me. I was like, well, this looks familiar, and sure enough, since I drafted it, I had a really nice assignment provision in there, and we were able to then just do a simple assignment of the agreement for sale to the new buyer for an assignment fee. I mean, pretty straightforward stuff. And but had that language not been in there, or had it been limiting language like some, contracts for deed or agreement for sale have, then it would be like, okay, how are we going to get this done exactly? Still may have been able to, but it may have been a lot more complex and a lot more documents involved and whatnot. But in any event, it made it really, straightforward as far as the documentation and what needs to get done to do that. There's more documents that still need to get done or drafted, and you have to figure out, okay, the warranty deeds and what gets recorded and whatnot. But as far as the actual transaction itself, it turned out to be a lot simpler than doing something really, really fancy.
So I got another question. What makes an estoppel happen? How would you answer that?
Estoppel is just something that one party relies upon and the other party knows that they're relying upon that and allows them to act accordingly, right? So an estoppel certificate from a tenant is a statement from the tenant representing that, my rent is current, there's no default under the lease by the landlord. And so the tenant knows, hey, I'm giving this to the new buyer, and the buyer's relying upon that in purchasing the property, and therefore the tenant is stopped or stopped. They can't go forward with now claiming that there's some problem with the property or the lease or the payments, because they've given you basically a representation and warranty as to the nature of the transaction. So it's basically actions, conduct, statements that you give and put forward, knowing another side is going to act upon that, and therefore you're stopped or you're prohibited from, taking an opposite approach later on.
Yeah, and I think they're important. It's an important thing. You use the example of the commercial example of tenants and estoppel certificates. They even use estoppel certificates knowing that usually a commercial lease itself already says in the lease that, I, as the landlord, have the right to sell this building. I might sell it, and you're going to be obligated to, any new owner. There's tons of language in a commercial lease that already plans for that contingency. And yet, a new buyer is going to go through the process of getting, those statements from you so that you can be stopped from claiming otherwise. It's pretty important as part of that transaction. All right. Let's see. If you're just now joining us, we're taking questions on creative finance. Through the hour, we've been going about, how long have we been going? About 36 minutes. We'll take questions until we don't get any more. If you're new and just out joining us, you can go to the link above. If you're watching us on Facebook, the barcode link up above will take you to our YouTube page. That's kind of the best place to follow this content that we do. We do a weekly podcast as well as the collective, which you're on tonight, which is an opportunity for us to just casually talk about creative finance and answer questions that investors or real estate professionals have or have run into about creative finance and ways that we can help them. So I think we're just about out of questions, or we are out of questions so far. Anything else you wanted to add before we cut out?
No, this has been good. Yeah, I think, having Alan on this morning and what we went over and some of the stuff we went over today, it kind of seems like very similar topics, and it's been good.
Yeah. All right, folks. Well, thanks for joining us. Look forward to seeing you next time. Make sure to join us and start posting your questions early. Like we said, we'll go the full hour as long as there's questions with that. Enjoyed it. We'll see you next week.